1.5 Anti-conversion laws. Recently, Karnataka Legislative Assembly passed the Karnataka Right to Freedom of Religion Bill 2021. So, this bill is also known as Anti-Conversion Bill. So, the Anti Conversion Bill deals with the prohibition of conversion from one religion to other by force, fraud, or marriage. So, the person who converts them by following practices is considered as an offender, and this offense is a non bailable, and there will be also penalties on him. So, not only Karnataka government, there are states in which these laws are in force. They are Odisha, Madhya Pradesh, Arunachal Pradesh, Gujarat, Himachal Pradesh, Chhattisgarh, Jharkhand, Uttarakhand, and Uttar Pradesh. So we have these anti-conversion laws from the pre-independence itself. So during 1930s and 1940s, the Hindu princely states passed these laws in order to preserve the religious identity from the Christian from the influence of Christian missionaries. Raigarh State Conversion Act 1936, Patna Freedom of Religious Act 1942, Udaipur State Anti Conversion Act 1946 are some of the examples of the anti conversion laws which were passed in the pre independence. So, even after independence, they tried to impose these laws but failed due to the lack of parliamentary support. Indian Conversion Bill 1954, Backward Communities Bill 1960, Freedom of Religious Bill 1979 are some of the examples which failed around after the independence era. But at present, in 2015, the Law Ministry stated that matters related to religion are of state subject, and also stated that legislating these laws by Parliament will not be according to the Constitution. So, the reasons for introducing anti conversion laws are: first is from fear of change in the religious population of the country. Next is to criminalize the forceful inducement or fraud conversion activities. The other is to strengthen religious freedom. Even Article 25 of Constitution of India mentions that religious freedom is not absolute, but it will be the subject to restrictions of public order, health, morality, and fundamental rights. That means if religious freedom destabilize the public order, health, morality, and fundamental rights of the other people, then protection of religious freedom is also needed. And India's legal system recognize only those conversions which are not done by force, threatening, or cheating others. The other reason for introducing anti-conversion law is because of Constituent Assembly database debates. So, during the Constitution Assembly debates, Sardar Patel has expressed his concern regarding the forceful conversions, and other members like uh, Ananta Sayanam Iyengar proposed that conversion should be banned and proposed conversion only on oath. Okay, oath should be permitted before a judge. So now let us look into some of the cases which challenged anti conversion laws and are closely related to anti conversion laws. So here the first case is Rev Stein Islas versus State of Madhya Pradesh and Orissa. So the court in this case supported the anti conversion laws of both the states on grounds of securing the freedom of conscience and public order. So, Article 25, Clause 1, which deals with freedom to propagate one's religion, did not grant a fundamental right to convert another person. The bench also ruled that converting purposefully would impact badly on the freedom of conscience guaranteed to all the citizens. So it also held that anti conversion acts will come under entry 1 of list 2, that is state list of the 7th schedule, and these are meant to avoid disturbances in public order by prohibiting conversions from one religion to other religion by restricting the conscience of community. So in the next case, Sarla Mudgal case 1995, here the Supreme Court stated that conversion to Islam is not valid if done only in order to practice polygamy. Polygamy means practice of having multiple wives. So again, in Lily Thomas case 2000, the Supreme Court clarified that prosecution of bigamy means having two wives. Okay, prosecution of bigamy was not a violation of freedom of religion under Article 25. So prosecution here means the process of proving someone as an accused. Okay, bigamy means having two spouses. So the third case is Lata Singh versus State of UP. Here, under this case, the Supreme Court stated that there should be a need for punishment in the case of violence or threats in intercaste or interfaith marriages. And the fourth case is M. Chandra versus M. Thangamuthu and another 2010. So, in this case, the Supreme Court laid down the test to prove the conversions. So, first test is there should be a conversion, and the second is the converted person should be accepted into their community. So, the next case, Arife alias Aarti Sharma versus Gopal Dutt Sharma 2010, and in Fahim Ahmad versus Mavia 2011. So under these both the cases, the Delhi High Court stated that religious conversions are being used for everything. Everything also, the example of this word everything is even for the membership of library. So but the court stated that the primary reason of conversion should only be of spiritual advancement. So now we'll look into the issues that are under the anti conversion laws. So first major issue is there is a problem of showcasing the conversion proof and whether the conversion was lawful or lies only on the person who was the reason behind the conversion. So, and also, these anti conversion laws focus more on the person who caused conversion rather than the opinion of the person who has converted. Next issue is some argue that these anti conversion laws are restricting the individual right to convert and might favor only one religion in future. So these laws are creating fear among the individuals, especially the couples who are willing to do intercaste marriages. The other reason is in the anti conversion law, the terms like fraud, force, allurement, etc., are not clearly defined. This can also lead to misuse of the act. And the next reason is these acts are against the freedom of religion, which is of integral part of human nature, and the ban on it may lead to violation of human rights. So, and even Article 18 Article 18 of Universal Declaration of Human Rights and Article 18 of International Covenant on Civil and Political Rights recognize the concept of freedom of religion, but the anti conversion laws are likely against them. And the next reason is they are also against the freedom granted by Special Marriage Act, under which the person belonging to two different religions get married. So even these are against this freedom granted by the Special Marriages Act. And the next last reason is the anti conversion laws also raise privacy concerns of the individuals who adopt their religion. So, this is also one of the major issue. And next, coming to the conclusion, the constitutional validity of the anti conversion laws in at least four states, that is Uttar Pradesh, Uttarakhand, Himachal Pradesh, and Madhya Pradesh, is still pending before the Supreme Court. Court has agreed to test the validity of these laws but has refused to stay on them. Any challenge to these laws would require the Supreme Court to relook at its Stanislas judgment, which while also taking the privacy of judgment into account.